Hello, everybody. Good to see you. It is, what is it today? God. Wow, I'm way out of it. Wednesday, January 20th already. God, we're almost through the month of January and this is New Year already. That's crazy. Excuse me. Today, well, actually, this was filed on Friday in Aaron Spencer's case, and it was just put on the docket yesterday. So I wanted to come on as soon as I could and share it with you guys. For those of you who aren't familiar with the Aaron Spencer case, let me tell you, you are in for some crazy. It's another Canton case, I think. I mean, basically, we have another Judge Canoni, and at times I think that this judge is even worse. If you ask me, I, put in the comments if you disagree, but I think she's just. Why is this? Okay, just one second. Let me change this. I don't know why it's doing this. Let's try this. Okay. Okay. Sorry about that. I want you to. This is hypothetical, okay? I want you to imagine that you're the father of a 13-year-old girl, a cousin of your daughter's, that your daughter has been groomed, essayed, and raped at the age of 13. It started when she was 13. She's now 14. By a family friend, a friend of a family friend, okay? And you find out this information also from the family friend, okay? You go to confront them and they tell you that they suspect that, yes, this is happening. You go through excuse me, you go through the steps of the legal process. You report it to the police. You have the police, do the interview with your daughter, do the interview with you. They arrest him. He's facing 43 felony counts. This is a 67-year-old man named Michael Fossler who has groomed, essayed, and raped this 13, now 14-year-old girl. So it's been going on for a little bit. So you're waiting for the legal process to take, it takes time, but you're waiting for it to follow the steps, okay? The judge in his case, knowing that has 43 felony counts, and they all center around this 13, now 14-year-old girl and the acts that were committed against her, okay? You give him a $50,000 bail, meaning you only pay 10%, so he's out on $5,000. 43 felony counts, including but not limited to grooming, child essay, and child rape. He gets out, and on October 1st, 2024, your daughter's dog starts to bark in her bedroom. So you go in and you check on her. You think she's in bed, but she doesn't respond to you. So you pull back the covers, and you notice that it's a stuffed animal with her hoodie on, made to look like she's in bed. She's gone. Your first thought is, oh my God, he's taken her. and now her life's in danger. Because you know, as well as Fossler knows, that there's one person standing between him and freedom. He is facing the rest of his life in prison, and for an ex-cop and a pedophile, that's a death sentence. We all know that. And there's one person standing between him and being free, and that's this 14-year-old child. She's the only witness in his criminal proceedings, in the trial that he's got upcoming. Okay? So as a father, what do you think? I'm thinking her life's in danger. So you get in your truck, you tell your wife to call the 911, explain to them what's going on, and you go out looking for her. And while you're driving and down this country road, you pass this white pickup truck, and you see your daughter in the passenger seat, and you know that this pickup truck belongs to Michael Fossler, the predator, the 67-year-old predator that has been assaulting your daughter for a year. He has come back, and he has restarted where he left off. So you turn around, you flash your lights, you honk your horn, you try to get him to pull over. He doesn't, so you perform a pit maneuver. He goes off the road, he hits a telephone pole and lands in a ditch. You're yelling for your daughter to get out of the pickup truck. She's not getting out because Foster's holding on to her and holding back and preventing her from getting out of this pickup truck. You walk towards the pickup truck. Fossler gets out, got something in his hand. You have your gun. You don't know what he has in his hand. So you fire. And you empty your clip 15 rounds into Michael Fossler. You then call 911 and you tell them where you are and that Michael Fossler, if they want Michael to if they want to save Michael Fossler, they better get here quick because he's going to die. Imagine that. Well, I'm here to tell you that Aaron Spencer, an Marine, I believe, veteran, Army veteran, family man, husband, father. He lives with his family on a small farm in Lonoke, Arkansas. Lonoke County, Arkansas. He doesn't have to imagine this because this is the hell that he's been living since that night. He's facing second-degree murder charges. And you may ask why. Well, good question. To me, he's a hero. To a lot of people, he's a hero. But this is small county, Arkansas, where there's corruption is afoot. You thought Massachusetts corruption was bad? It holds nothing to this place. So he's arraigned and everything, and he come to find out the judge overseeing Aaron Spencer's case, murder trial, is the same judge that released Michael Fossler on $5,000 bail. You heard it. You can't make this stuff up. Same judge is going to oversee his case. And needless to say, she has been anything but impartial. Aaron's been fighting for everything he's been given. The idea of a fair trial has been lost in this county, in this courthouse, and it is truly appalling, to say the least. This man is fighting for his life because a creep, a creature, a monster subjected his daughter to the unimaginable. It's a parent's worst nightmare. And Aaron Spencer did what he had to do to protect his daughter. There was no other option. He had no reason to believe that his daughter was going to be safe with this man. Michael Foster's already subjected this girl to unimaginable harm. Things that she will be dealing with for the rest of her life. And now she's the only witness set to testify against him in a 43 charge trial, felony trial, that could put him in prison for the rest of his life. He's an ex-cop. He's a pedophile. We all know he wouldn't survive. So what do you think he was going to do with her? Mind you, he had already reoffended against her that night. He had already reassaulted her and raped her again. And the prosecutor would have you believe that this is all on the girl. She wanted this. She consented. She snuck out. Well, that's what grooming's about. She's 14 years old. It doesn't matter what she wants or what she thinks she wants. And for the prosecutor to make it about her and what she did to be put in this position is disgusting. It's vile, and I hope to God he has no kids, much less daughters, because karma's a bitch, and I will give her your number if she doesn't have it, because I would never wish anything bad on your daughters. Or have you heard of the word empathy? Have you heard of the word victim? Have you heard of the word grooming? How dare you put this on the girl? This man was a predator. He had a history of being a predator. He should have been held without bail. But if you're going to give him bail, it better be a hell of a lot more than $5,000 fucking dollars. I'm telling you, bro. I mean, I can't even wrap my head around what the judge must have been thinking. And the judge's name is Barbara Elmore. And you will see in this filing that I'm going to read you today just how far she has taken this bias towards Aaron Spencer. I had no idea that all this was going on because, of course, Barbara Elmore has made this trial closed to media. And she's limited the amount of public that's allowed to come in and watch this trial. And I'm here to tell you, you have a constitutional right to a public trial. That's your right. And she's shitting all over it. She could give a shit about the Constitution. She just doesn't care. And she doesn't care who knows it. She does not want this case to go public because she knows how nefarious she's behaving. I don't know if she's got some kind of connection to Michael Foster or Michael Foster's family, but she has made it pretty clear that she has no intention of making this easy for Aaron Spencer. And I hope that this gets out, and I hope people are made aware of the injustice that's going on in Lonoke County. Now, since all this has transpired, Aaron Spencer has put his hat in the ring for sheriff of Lonoke County. And God willing, he gets elected and he goes through this county and the authorities therein and just cleans house. Just gets rid of every piece of shit in there. That is only if he's found not guilty. If he's found guilty, then Lonoke County's in for a long haul. Their judges in Lonoke County are elected officials, and I would hope that one of his first, and 2026 is an election year. And I hope that one of the first things that the good folk of Lonoke County do is vote Barbara Elmore out of office. Get her off the bench. She has no business being on the bench. This is not her only poor decision on the bench. And this is not her only, and not only was it a poor decision to let him out on bail, such a low bail, you will see in this filing just how far she's gone to protect that decision, to keep it from the public, to make the public unaware and keep them in the dark about all the shit that ultimately her decision caused. Aaron wouldn't be in this situation, and Michael Fossler wouldn't be dead if she didn't give him such a low bail and make it so easy for him to reoffend, get out, reoffend, kidnap his daughter. He'd still be alive, and he'd still be standing trial. But he got the ultimate sentence, and I'm not sorry about that, but I am sorry that Aaron Spencer is now having to face criminal charges because of it. So without further ado, let's begin, because it's a pretty lengthy filing, and I have to work again. I have to work tonight, the first of 5. So, yeah. Let me see. Okay. Okay, it's 16 pages. So let me see. So yeah, I want you guys to put down in the comments what, when we went through that hypothetical at the beginning, what you would have done if you were faced, if you were in that situation with what Aaron Spencer, what would you have done, Aaron Spencer? Would you have led, put down in the comments what you would have done. I would like to think that I would have filled him with lead. But I guess you never know until you're in that position, right? So, there's that. Okay. I'm going to use red because I'm going to mark out the ugly words. This is the Arkansas Supreme Court. She spelled it all right this time. Aaron Spencer, petitioner, State of Arkansas, respondent. Petition for writ of certiorari and other relief, emergency consideration requested. Petitioner Aaron Spencer respectfully requests emergency consideration of his petition for writ of certiorari, I believe that's how you say that word, to vacate an unconstitutional order issued sua sponte by the circuit court, purportedly, quote, in the interest of maintaining courtroom security, decorum, and the orderly administration of justice, end quote. Spencer's jury trial is set to begin in 10 days on January 26, 2026. The challenged order operates as a de facto courtroom closure by sharply limiting public and media attendance and by providing no alternative means for observing the proceedings. In violation of Spencer's Sixth Amendment right to public trial and the First Amendment rights of the public and the press, the circuit court entered the order without receiving evidence, holding a hearing, identifying a compelling or overriding interest, ensuring that just one second. Start that over. In violation of, sorry, I have a new puppy and she's making quite the racket, so bear with me. In violation of Spencer's Sixth Amendment right to a public trial and the First Amendment rights of the public and the press, the circuit court entered the order. The circuit court entered the order without receiving evidence, holding a hearing, identifying a compelling or overriding interest, ensuring that a closure is no broader than necessary, considering reasonable alternatives, or making the findings required to justify any courtroom closure. This failure is particularly stark because earlier in this same case, this court expressly instructed the circuit court that any closure must be supported by an evidentiary basis and must comply with constitutional analysis required under Walter v. Georgia. Rather than adhering to that guidance, the circuit court again imposed a sweeping restriction on public access without constitutional justification. As with the entry of the gag order, the entry of the security order was a plain, manifest, clear, and gross abuse of discretion, and there is no other adequate remedy but for the writ. Spencer therefore asked this court to grant the writ of certiorari and vacate the security order. Spencer further asked the court to exercise its superintending authority and reassign this matter to a different circuit court judge. Emergency consideration is warranted under Arkansas Supreme Court Rule 6, 1B, because Spencer's trial is scheduled to begin on January 26, 2026, leaving insufficient time for the ordinary consideration before irreparable constitutional harm begins, or occurs. Sorry, just one second. Okay. 1. Procedural history and background. Spencer is charged by amended felony information with second-degree murder, along with a firearm enhancement under Ark Code 1690 through 120 for the shooting death of 67-year-old Michael Fossler. RP3, I don't know what that means. The circumstances of the shooting were as follows, and then it says footnote 1. See generally Background resided in Spencer v. State, 2025 Arkansas 91 at 1712. Search warrant 3D, whatever. In July 2024, Fossler was arrested for numerous sexual offenses against Spencer's teenage daughter and released on bond. The state later filed 43, mind you. Let's make it a skinny. 43 felony charges against him. Several months later, on October 8th, 2024, Spencer and his wife awake to, it was October 8th, not October 1st. My bad. Spencer and his wife awoke to his dog barking and realized that his daughter was gone. As a result, they called police and he left in his truck to search for her. Spencer located Fossler's truck with his daughter inside and he forced it off the highway. After an altercation, Spencer called 911 to report that he had shot Fossler, who died at the scene. From its inception, the case has drawn intense public scrutiny and debate over the circuit court's decision to release Fossler on a low bond despite facing numerous felony charges and potential life sentences. The propriety of charging Spencer for actions taken in defense of himself and his child, and the integrity of local law enforcement given its loss of critical evidence, including video of the events that concluded with the shooting, rather than permitting that scrutiny to occur through open judicial proceedings, the circuit court repeatedly acted to restrict public access to information about the case. First, at Spencer's arraignment in November of 2024, the circuit court closed the courtroom to the public in violation of Spencer's constitutional right to a public trial, to attend the trial. When defense counsel objected, the circuit court refused to hear argument and directed counsel to file a motion and brief, despite that the proceeding would conclude before any relief could be obtained. This immediate restriction on public access set the tone for the subsequent proceedings. She's not fucking around. On December 10, 2024, without holding a hearing or receiving evidence, the circuit court entered a gag order and sealed the entire case. Spencer, 2025, Arkansas 91 at 3. Spencer sought extraordinary relief and filed a petition for writ of certiorari in this court. After full briefing and oral argument, this court granted the writ and vacated the gag order, holding that it constituted a plain, manifest, clear, and gross abuse of discretion. Spencer, 2025, Arkansas 91 at 7 and 18. In light of the circuit court closing the courtroom during Spencer's arraignment, the court also cautioned the circuit court against closing further proceedings to the public. Quote, without an evidentiary basis and an adherence to the required constitutional analysis, end quote, set out in Waller v. Georgia. Despite this history, the December 18, 2025 pretrial hearing culminated in what functioned as a partial courtroom closure when the circuit court ejected a member of the defense team from the courtroom without notice, findings, or adherence to the constitutional framework governing closures. The attorneys seated with defense staff directly behind counsel's table used a phone in silent mode to research an evidentiary issue at lead counsel's request while a video exhibit played. Without any prior instruction restricting such conduct and despite no disruption to the proceedings, the circuit court abruptly stopped the video and ordered the attorney removed from the courtroom. The circuit court's subsequent statements made clear that the removal was prompted by her belief that someone was reporting on the proceedings via social media, rather than by any concern related to witness intimidation, courtroom disruption, or other interests that could justify a limited courtroom closure. ID. Despite well-settled First Amendment protections for reporting on public proceedings, the circuit court suggested that any periodic public reporting on the events inside the courtroom would be prohibited. Crucially, on January 13, 2026, 13 days before trial, the circuit court, sua sponte, entered a new order invoking the invoking, quote unquote, the interest of maintaining courtroom security, decorum, and the orderly administration of justice. The January 13th order sharply limits public and media access to Spencer's trial. Only 20 members of the public and media would be permitted to attend voir dire. After the jury is seated, attendance is limited to 55, quote unquote, inclusive of parties, counsel staff, family members, observers, and media. The seating, including for media, would be, quote, on a first-come, first-served basis until the courtroom reaches capacity, end quote. And I have read that their maximum capacity in the courtroom is 75 people. So she's not even to maximum occupancy, which is bullshit. Total violation of his constitutional right to a public trial. And that's what she wants. The order also prohibits all, quote unquote, recording devices, including phones, watches, iPads, recorders, and eyeglasses. The circuit court provided no overflow courtroom, no alternative means for the public to observe the proceedings, and no explanation for why such sweeping limits were necessary, particularly since the courtroom contains many additional seats, both in the gallery and inside the railing. As a result, the order operates as a functional courtroom closure. Members of the public and press who wish to observe the trial will be excluded once the numerical cap is reached, even though the courtroom itself remains nominally, quote-unquote, open. The circuit court made no findings identifying any specific security threat, an overriding or a substantial interest likely to be prejudiced, reasonable alternatives, and no findings demonstrating that the restrictions are narrowly tailored. There had been no disruption, violence, or security in prior proceedings that would justify such measures. On January 16, 2026, Spencer also filed a motion in the circuit court respectfully requesting that Judge Elmore recuse herself as the presiding judge pursuant to Rule 211A of the Arkansas Code of Judicial Conduct. The motion contends that, based on the cumulative course of proceedings, the circuit court's impartiality might reasonably be questioned. It identifies a pattern of rulings and conduct that create the appearance that the circuit court has responded defensively to public criticism and appellate intervention rather than correcting course. Footnote 2, due to the late hour of filing and the intervening court holiday, the motion may not be docketed until Tuesday, January 20th. At the time of filing of this petition, the recusal motion remained pending. If the circuit court denies it or refuses to rule on the motion, Spencer asks this court to reassign his case to preserve both the appearance and reality of a fair trial. Wow. 2. Standard for issuing a writ of certiorari. A writ of certiorari is extraordinary relief. 2 requirements must be satisfied in order for this court to grant a writ of certiorari. First, a writ of certiorari lies only when 1. It is apparent on the face of the record that there has been a plain, manifest, clear, and gross abuse of discretion, or 2, there is a lack of jurisdiction, an act in excess of jurisdiction on the face of the record, or the proceedings are erroneous on the face of the record. Second, there can be no other adequate remedy but for the writ of certiorari. This court has held that a writ of certiorari is an appropriate remedy when reviewing decisions to close the courtroom to the public and prior restraints on speech. Then it notes case law. There is no avenue for relief unless the court intervenes prior to the trial. Post-trial appeal would not provide an adequate remedy for Spencer's right to a public trial, nor would it vindicate the rights of the public and the media to attend the proceedings, particularly in the event of an acquittal. Spencer therefore seeks emergency certiorari relief, vacating the January 13th security order. 3. The order was a plain, manifest, clear, and gross abuse of discretion. The sua sponte security order violates First and Sixth Amendments to the U.S. Constitution in Article 2, 6, and 10 of the Arkansas Constitution. No record was developed to support the order, and the Circuit Court made no findings justifying any restriction on public access. The order is on its face a plain, manifest, clear, and gross abuse of discretion and in excess of the Circuit Court's authority. A. Standard for closing the courtroom. Both the Sixth Amendment to the U.S. Constitution and Article 2:10 of the Section 10 of the Arkansas Constitution guarantee that, quote, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, end quote. This court has recognized that the right to a public trial is one of the most important safeguards in the prosecution of persons accused of crime, end quote. In Waller, the U.S. Supreme Court adopted the following test for determining when the right of an accused to a public trial may give way to other interests. For example, when the closure of a courtroom is justified in a criminal trial. 1. The party seeking to close the hearing must advance an overriding interest that is likely to be prejudiced. 2. The closure must be no broader than necessary to protect that interest. 3. The trial court must consider reasonable alternatives to closing the proceeding. And 4. It must make findings adequate to support the closure. Waller v. Georgia. Additionally, the press and the general public have a constitutional right of access to criminal trials under the First Amendment, made applicable to the states through the 14th Amendment. See Presley v. Georgia. This court has recognized that an accused may assert his constitutional right to a public trial by arguing that exclusion of the news media and the public This court has recognized that an accused may assert his constitutional right to a public trial by arguing that exclusion of the news media and the public violates that right. See Taylor v. State. Even more broadly protects freedom of speech and of the press. Arkansas Constitution, Article 2, Section 6. Spencer, 2025, Arkansas 91 at 19. And it gives some other case law. Quote, the sittings of every court shall be public, and every person may freely attend the sittings of every court, end quote. B, the security order effectively closes the courtroom. The January 13 order imposes severe limits on public access to Spencer's trial. Once a jury is seated, only 55 individuals, quote, inclusive of parties, counsel staff, family members, observers, and media, end quote, will be permitted to attend. Seating is, quote, first come, first served until the courtroom reaches capacity, end quote, with media included in that same pool. As a result, if members of the family and public occupy the available seats first, members of the press may be excluded entirely. And that's what she wants. Media access is further restricted to a single representative per outlet, and media must be unspecified, quote-unquote, credentials. The order does not allow seat reservations. Quote, once an individual visitor leaves the courtroom, their space shall not be held or reserved and may be reassigned to another individual, end quote. Although the order creates a limited exception for, quote, individual news media for that particular day, end quote, it provides no guidance as to what qualifies as quote unquote individual news media or how such an exception is obtained. The absence of standards or procedures renders the exception illusory and arbitrary. By counting counsel staff, and family members toward the 55-person limit, the order ensures that most of the available attendance spots will go to trial participants rather than the observers. The Circuit Court required the parties to submit lists of counsel team members and family, which together accounted for approximately 40 individuals. Even allowing for sequestration or scheduling absences, the order leaves only a handful of seats for public and press attendance at a trial of intense public interest. The seating restrictions are further exacerbated by arbitrary limitations on where defense counsel and staff may sit within the courtroom. The circuit court permits only 3 members of the defense team to sit at counsel table and prohibits any additional defense staff from sitting inside the rail, behind or close to the counsel's table. That's just bullshit. As a result, defense staff are required to sit in the gallery outside the rail, occupying seats that would otherwise be available to the public or the media. If the circuit court allowed available space inside the rail to be used by counsel and staff, a meaningful number of public seats would be freed. These restrictions are also difficult to justify given the physical layout of the courtroom. Footnote 3. Photos of the courtroom are available on the American Courthouse's photo archive. This is such bullshit. The gallery alone contains at least 75 individual seats, not benches. In addition, counsel tables are large enough to accommodate more than the 3 permitted staff members, which would free up additional seating in the gallery. There is also a largely unused area on the opposite side of the courtroom from the jury box, occupied by a large conference table that remained empty throughout most of the pretrial proceedings. During the pretrial hearing, additional chairs lined the wall of the courtroom, providing additional seating. Finally, the order provides no alternative means of public access. It does not allow for an overflow room, audio feed, video feed, or any other mechanism by which members of the public or the press, excluded by the seating cap, may observe the proceedings. To the contrary, the order also imposes sweeping technological restrictions, banning, quote, all recording devices including cameras, cell phones, Apple Watches, iPads, recorders, and eyeglasses, end quote. As written, this prohibition extends to laptops, tablets, and phones used by counsel, even when not used to record. In addition to crippling the defense's ability to manage a case involving extensive digital discovery, the restriction confirms that the circuit court does not intend to provide any audio or visual accommodations to ensure meaningful public access. In the absence of such accommodations, the order closes early selected group, notwithstanding the constitutional presumption of open criminal proceedings. C. The January 13th security order was entered without an evidentiary basis or adherence to the required constitutional analysis. Contrary to this court's guidance provided to the circuit court via the writ of certiorari in Spencer v. State 2025, Arkansas 91 at 17, the trial court entered the January 13th order without an evidentiary basis or adherence to the required constitutional analysis set out in Waller 467 U.S. at 48. The circuit court entered the new order sua sponte, that means without notice, on her own, spontaneous, basically, without a motion from either party, without notice or hearing, and without receipt of evidence. No record was developed before the circuit court to demonstrate why the closure of the courtroom is necessary. There was no evidence presented on which the circuit court could have determined, 1, that there was an overriding or substantial interest likely to be prejudiced, or 2, how broad any closure might need to be, or 3, what reasonable alternatives to closure might exist. The circuit court made no findings identifying any specific security threat, an overriding or substantial interest likely to be prejudiced, or what other reasonable alternatives it had considered. No findings demonstrating that the restrictions are narrowly tailored or otherwise as necessary to support the closure. The circuit court did state in conclusion that it finds, quote, that this order constitutes a reasonable, narrowly tailored regulation of the courtroom access that fully preserves the defendant's Sixth Amendment right to a public trial while safeguarding the integrity and orderly conduct of the proceeding, end quote. However, without an evidentiary foundation or analysis, this bald pronouncement is insufficient to meet the constitutional mandate. Spencer's jury trial is scheduled to begin January 26, 2026. The January 13th order operates as a functional courtroom closure and directly conflicts with this court's prior ruling and lacks even an attempt to comply with the constitutional framework in Waller. For these reasons, it is apparent from the face of the order that it is a plain, manifest, clear, and gross abuse of discretion. 4. Exercise of superintending duty is appropriate to reassign this case. This case has exercised its superintending authority to grant expedited relief and reassign cases when a circuit court persists in conduct that undermines public confidence in the judiciary. Exercise of that authority is appropriate here. As detailed in Spencer's motion for judicial recusal filed in circuit court on January 16, 2026, the circuit court's actions following this court's remand did not reflect correction or restraint. Despite this court's express mandate emphasizing the constitutional presumption of openness, the circuit court continued to restrict access to public records, excluded a defense attorney from a public pretrial hearing based on suspicion of social media reporting, and ultimately entered an order that at least partially closes the courtroom during trial. I just have one thing to say. How did she know that there was any updates in the social media unless she was on social media during that hearing? 1. Can anybody tell me that? So she's on social media during a pretrial hearing that she's overseeing? What the fuck? Also, while I support Aaron Spencer's filing of this motion, and I support the balls that it took for his lawyer to file said motion, I'm concerned that this might give her more reason and more incentive to act out against Aaron Spencer more than she has been. She's pretty biased. She's pretty openly biased currently, and has been since the onset of this case. And she's flagrant about it. She's flagrant. She's openly biased against him. She doesn't even try to hide it, okay? So my concern is that this is just going to give her more reason to treat him badly and make decisions against Aaron Spencer and against his best interests because she's going to be pissed. Because she's going to, just like Judge Canoni, Judge Elmore is going to rule on this herself, I think. Or has ruled on it herself. Or it's in the process of being ruled on. It hasn't been ruled on yet. But I am concerned that Aaron Spencer might be putting himself in jeopardy where his trial is concerned because she doesn't give a shit. I think that's plain and simple. And I just don't want him to hurt what chances he has at a fair trial. That's all I'm saying. Because this bitch doesn't care. It's obvious. Those actions did not occur in isolation. They were accompanied by an extraordinary security force at the December pretrial hearing. I was so shocked to hear about this. One far exceeding anything reasonably justified by the circumstances of this case. Although Spencer is a non-custodial defendant with no history of escape attempts or disruption of prior proceedings, at least 4 and sometimes as many as 6 Arkansas State Police officers were stationed inside the courtroom at all times. Additional officers occupied hallways, stairwells, elevators, and building entrances. Police vehicles ringed the courthouse and established an outer perimeter while drones patrolled overhead. You don't get this kind of security for the president. Parking in surrounding lots was prohibited. All attendees were searched, electronics were banned, and even defense counsel's briefcases were inspected. From the outside, the courthouse appeared closed to the public. Counsel has reason to believe that an even greater show of force will accompany the trial. And I heard that they also had a cop standing right over Aaron Spencer's shoulder through the whole pretrial hearing. Now, what does that say? If there was a jury present, what would that say to the jury? He's not even in custody. Okay? For fuck's sakes. Get your shit together, Arkansas. Viewed cumulatively, these measures discourage public attendance, insulating both the state's conduct and the circuit court's own decisions from contemporaneous scrutiny. They convey the message that Spencer is too dangerous for a public trial, that the public cannot be trusted to witness it, and that those who speak about what occurs may face sanction. That message fosters an appearance of bias and erodes confidence in the judicial process. And I say hallelujah to that. These concerns are heightened here. Spencer is a declared candidate for public office with a primary election approaching on March 3rd, 2026. And his political opponent is both a witness in this case and a public official with whom the circuit court has worked professionally for more than a decade. In that context, continued efforts to limit public access amplify the appearance of bias and entrench the perception that the circuit court is responding to scrutiny by constricting it, rather than adhering to this court's mandate. Where a court responds to appellate correction not by conforming its conduct, but by entrenching it, this court's intervention is necessary to preserve both the appearance and reality of impartiality. For these reasons, Spencer respectfully asks this court to grant emergency consideration, issue the writ of certiorari, vacate the January 13th order, and exercise its superintending authority to reassign this matter to a different circuit court judge. Respectfully submitted, Michael Kaiser, Aaron Casanelli, attorneys for Aaron Spencer. So, but like I said, I have to work tonight, so I do need to go to sleep. And, I would have come on sooner, but I was working out and, doing the shit that we have to do. But let me know in your comments what you think, how you think this is going to go over. And do you think the, higher court is going to grant the writ? The only promising thing about that is they did write that in their prior decision to lift the gag order on this case. They made, they stated in their ruling to lift the gag order, they stated that they felt that it was highly discouraged that the Judge Elmore stay on this case. They made it clear that they felt that she should recuse herself, and they were surprised that she hadn't yet, and if she still hadn't as of the time of their ruling, that she should. So that's my only hope for this, working out for them, because the higher court did make that statement. It's like, there was a more, man, they really went through and cleaned this out. You can't find anything in here now. What the fuck? Because there was a more detailed motion that actually went into detail on some of the things that she was referring to, and this is just kind of like a revised overview of that particular motion. And I wish we had the original motion, but they cleaned everything out of the docket entries. There's nothing listed. That's crazy. Oh, wait, maybe it's here. Maybe. Because she goes off. Just 1 second. Let's see if I can find it. Nope. Oh, wait, I might. Oh, yeah, we do have it. Here's the actual. Let's see. Okay. Okay, defendant's motion for judicial recusal. Defendant Aaron Spencer respectfully moves for recusal of the presiding judge pursuant to Rule 211A of the Arkansas Code of Judicial Conduct. The cumulative record of these proceedings results in reasonable court's impartiality. This case arises from the killing of Michael Fossler, who had lured Spencer's minor daughter from her home while facing dozens of felony charges arising from sexual offenses against her. Sorry about that. Oh my God. Fossler was free on bond at the time. Bond issued through this court and was killed during Spencer's efforts to recover his child. From its inception, this case has drawn intense public scrutiny regarding the court's decision to release Fossler on bond, the propriety of charging Spencer for actions taken in defense of himself and his child, and the integrity of local law enforcement given its failure to preserve critical evidence. Sorry. Spencer, his counsel, his family, and others have publicly criticized these actions. In early proceedings, the court entered an expansive gag order, sealed the case, and limited public access without a hearing or factual findings. The Arkansas Supreme Court Okay, sorry about that. Now, where was I? The Arkansas Supreme Court granted certiorari and vacated the order, expressly cautioning against courtroom closures or secrecy imposed without adherence to constitutional requirements. So Spencer v. State, 2025. Several justices warned of a, quote, troubling pattern of attempts to shield this case from public view, end quote. That in their opinion, warranted reassignment even then. So that's them saying that she should recuse herself. Following the Supreme Court's intervention, the court's subsequent rulings have reinforced, not alleviated, concerns about impartiality and secrecy. The court imposed compressed and impractical scheduling directives while discovery was still being produced, required duplicative filings shortly before major deadlines, and denied defense requests for additional time despite late disclosures by the state. During the pre-trial hearing, the court curtailed discussion of Fossler's abuse and its relevance to the defense, permitted the state to proceed with expert testimony despite belated discovery related to that expert, and mischaracterized defense advocacy as improper. The hearing culminated in a public accusation of misconduct against a member of the defense team made without evidence and in open court, resulting in that attorney's removal and exclusion it was basically for the day. The attorney violated no rule and did nothing improper. The episode publicly branded the defense as untrustworthy and reinforced the perception of hostility toward defense counsel. Most recently, the court entered a sua sponte order limiting public and media access to trial, capping attendance, and providing no alternative means of observation, again without evidence, findings, or consideration of alternatives. That order functions as a courtroom closure and mirrors the secrecy concerns already condemned by the Arkansas Supreme Court. Viewed cumulatively, these actions create a reasonable perception that the court has responded defensively to public criticism and appellate review rather than correcting course. The appearance of partiality is further magnified by the nature of the trial itself. A substantial portion of the defense will focus on investigative failures by local law enforcement, including the failure to secure and preserve evidence. The court will be required to rule repeatedly on objections, scope of cross-examination, impeachment of law enforcement witnesses, and expert testimony addressing these failures. The court's longstanding professional relationships with local law enforcement create an appearance problem in this context. Regardless of subjective intent, under the unique circumstances in this case, a reasonable observer would question whether a judge with institutional ties to the very agencies whose conduct will be scrutinized can impartially adjudicate those disputes. The concern is further magnified by Spencer's current status as a candidate for public office. Spencer is now a political actor and, by extension, a political adversary of a public official expected to be a witness in this case and with whom the court has worked professionally for many years. Spencer decided to run for office in significant part as a result of his experiences with these officials and has campaigned on those issues. His criticisms constitute protected political speech, but they nevertheless place the court in a position where its rulings may reasonably be perceived as entangled with institutional loyalty or political context. Recusal is required where a judge's impartiality might reasonably be questioned. Arkansas Code Judicial Conduct. Here, where the court will preside over disputes directly implicating law enforcement conduct, where public confidence has already been strained by prior rulings, and where the cumulative record reflects a pattern that reasonably suggests partiality. Reassignment is necessary to preserve both the reality and appearance of a fair trial. She's quite the cuddler. She does not like to be, she likes to be held when she's tired, and it's nap time, so. Spencer respectfully requests that the court recuse from further participation in this matter and that the case be reassigned to another judge. Spencer does not object to entry of an order of recusal without a hearing. In the alternative, he requests a hearing on this motion. Wherefore, the defendant, Aaron Spencer, asks the court to recuse from this case and seek expedited appointment of a specially appointed judge and for all other relief to which he is entitled. So, I'm telling you, this attorney's really putting it all out there, and it just, like I said, it just makes me a little nervous where, you know, the trial's concerned, because if she doesn't get recused, then she's going to be overseeing his trial, and what are the ramifications of all of this going to be? You know what I mean? Would she be dumb enough to actually retaliate against him? Who knows? She's tired. She won't let me put her down, though. So let me see if I can find the... Can I put you down? I know. It's okay. I'll lay down. Sorry about that. She's a little human, so she thinks she needs to be held all the time. Let me see. That's not it. Come here. Come here. What's wrong? That's 52 pages. That's just the exhibits for the recusal. Let's see what this is. I think this is the one I wanted to read to begin with, so we might have to go a little longer. I may not get any sleep, because I think this is the one that she just tears this judge up. So I have to show it. Okay. Get my highlighter. Defendant's brief in support of motion for judicial recusal. The defendant, Aaron Spencer, asks Your Honor to recuse herself as the presiding judge in this case. While Spencer still holds the... Just one second. Still holds the unshaken belief that the courts remain a place where justice is sought, not defended. The court's comments and conduct have cast doubt on the constitutional guarantee of a neutral and open tribunal. From the onset of this case, Spencer, his counsel, his family, and others publicly criticized the actions of Lonoke County officials. Just one second. Lonoke County officials, including the prosecuting attorney, law enforcement, and the court. The court's decision to release Fossler on bond, the proprietary of charging Spencer for actions taken in defense of himself and his child, and the integrity of local law enforcement given its failure to preserve critical evidence. As the proceedings unfolded under increasing public scrutiny, the court has repeatedly restricted public access, constrained defense advocacy, impeded transparency, and responded defensively to oversight. Viewed cumulatively, this pattern gives rise to a reasonable perception that the court is aligned against the defense and is seeking to shield its prior conduct from public examination. The court's conduct undermines the appearance of impartiality that Rule 211A of the Arkansas Code of Judicial Conduct is designed to protect, which requires recusal. Here's the table of contents. Legal standard. Rule 211A of the Arkansas Code of Judicial Conduct provides that a judge shall disqualify herself in any proceeding in which the judge's impartiality might reasonably be questioned. This duty is mandatory. Arkansas courts have emphasized that the analysis must be undertaken from the perspective of the litigant and the public, not the subjective intent of the judge. A trial judge is presumed impartial, and the party seeking recusal bears the burden of demonstrating otherwise. But where conduct goes beyond conclusory allegations and raises a reasonable question of impartiality, a hearing is required. Rule 1.2 requires that a judge, quote, that a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety, end quote. Comment 5 explains that the test for appearance of impropriety is whether the conduct would create in reasonable minds a perception that the judge violated the code or engaged in conduct that reflects adversely on the judge's honesty, impartiality, temperament, or fitness to serve. I think fitness to serve should be addressed. The Arkansas Supreme Court has explained that quote-unquote shall is mandatory rather than discretionary. Comment 1 further provides that a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any specific provisions apply. As the Arkansas Supreme Court has stated, if a judge's impartiality may quote-unquote reasonably be questioned, Rule 2.1a is invoked and disqualification is required, and Arkansas case law requires a circuit court to remain mindful of the perception of bias from the litigant's perspective. Rule 2.3 prohibits a judge from manifesting bias or prejudice by words or conduct and requires the judge not to permit court staff or others subject to the judge's control to do so. The comments recognize that even facial expressions and body language can convey an appearance of bias or prejudice, and a judge must avoid conduct that may reasonably be perceived as prejudiced or biased. Rule 2.8 similarly requires a judge to be patient dignified and courteous to litigants, witnesses, lawyers, and others. Background. She really goes for the jugular on this, and I love it. Aaron Spencer intends to show at trial that he killed 67-year-old Michael Fossler while defending his then 14-year-old daughter. When Fossler had lured her from her home in the middle of the night. At the time, Fossler faced 43 felony charges threatening life sentences, all arising from the sexual exploitation of Spencer's daughter, including SA, internet stalking, and CP. Let me draw a line through this stuff because that's going to get us. And yet, Fossler was free on bail on the night of October 8, 2024, released by this circuit court. When Spencer discovered his daughter was missing, he contacted law enforcement and began searching for her himself. He soon encountered Fossler's truck and saw his daughter inside. Fossler fled with the child as Spencer followed. Spencer feared not only renewed abuse, but that Fossler would eliminate the sole witness standing between him and a life sentence. To prevent further harm to his child, Mr. Spencer forced Fossler's truck to stop. Fossler exited the vehicle and continued to pose an imminent threat to Mr. Spencer and his daughter. Mr. Spencer killed Fossler to protect himself and his child. Reasons why recusal is required. The court has exhibited both apparent and actual bias against Spencer and his legal team, such that the court's impartiality is reasonably in question. Spencer does not make this motion without serious consideration of the issues herein. However, given the seriousness of the proceeding and the unusual circumstances involved, defense counsel must make all efforts to safeguard Spencer's constitutional rights to due process and fair trial before an impartial tribunal. Early proceedings restricting public access. Okay, we already went over that stuff, so let's skip that part. Arkansas Supreme Court intervention and expressed concerns about this court. The Arkansas Supreme Court granted a writ of certiorari and vacated the gag order on May 29, 2025. And yet, she did not openly lift the gag order until June or July, I believe. She waited that long, which really cut into the time that the public was able to access anything about this trial. 3 justices wrote separately to concur and express concern about the circuit court's repeated efforts to shield proceedings from public view, including closure of arraignment, sealing of the case, and the timing and breadth of the gag order. Those justices explicitly raised concerns that the gag order functioned to suppress public criticism of the state and the circuit court for setting Fossler's bond low, thus facilitating his release and setting in motion the chain of the events leading to the confrontation at issue. They suggested that this matter should be assigned to a new circuit court judge because, quote, anything less suggests that what's happened so far is within the acceptable range of disagreement or administration, and it isn't, end quote. This intervention weighs heavily in assessing whether a reasonable person could question the court's impartiality. During that same period, defense counsel attempted to verify information reported about Michael Fossler's bond, a proceeding that, from all available records, traces back to the circuit court. The district court confirmed it had no record of any appearance by Fossler, Exhibit A. The circuit clerk produced the information in a 1-line docket sheet, but no bond order, Exhibit B. The court reporter confirmed that no verbatim record of Fossler's bond proceeding was made, and no waiver of such record appears in the court's file. Arkansas law mandates that a complete record be made of all circuit court proceedings unless waived by the parties. Yet, Despite repeated requests for what should have been a public and complete record of the court's business, no such record was located. Both before and after the gag order, Spencer and his representatives have been publicly critical of Lonoke County officials, including the prosecuting attorney, law enforcement, and the circuit court. That criticism focused in part on the circuit court's handling of Fossler's release on an unreasonably low bond with no meaningful restrictions or supervision, and on the prosecutor's decision to charge Spencer under those circumstances. The issue of who set Fossler's bond was raised in Spencer's opposition to the gag order motion, discussed in multiple briefs and discussed before the appellate court. Throughout the entire period, neither the state nor the court ever suggested that anyone other than this court had set Fossler's bond. The silence is significant. On May 29, 2025, the Arkansas Supreme Court granted Spencer's petition for writ of certiorari and vacated the gag order. Only under the Supreme Court's rebuke on June 5, 2025, did the state for the first time email defense counsel a document purporting to show that Your Honor had not personally signed Fossler's bond order. That document had never been produced in discovery with the rest of Fossler's case materials, was not provided by the circuit court despite prior requests, and appears nowhere on any docket through case search. It is barely legible, lacks a case number, lacks a file mark, and bears the title of a circuit court order, even though it purports to be signed by a district judge. The sudden emergence of this unidentified, unfiled document after months of silence and only following the Supreme Court's criticism raises serious questions about transparency, record integrity, and possible attempts to retroactively obscure the process that led to Fossler's release on bond. Whether this court personally signed the order or directed another judge sitting in the circuit court to do so, the bond was issued through this court, and this court subsequently presided over Fossler's criminal case. That case charged 43 offenses, including additional felony counts of a different nature not known at the time of the arrest. Despite new and serious allegations, the court never revisited or modified the bond conditions. Instead, this court allowed Fossler to waive arraignment, set pretrial and trial dates, sealed the affidavit supporting the arrest warrant, withheld the felony information from public access, and he should have been registered as a sex offender, mind you. Entered final judgment after Fossler's death and sealed his death certificate. A year later, when defense counsel again sought a certified copy of the order granting bond, the same resistance reappeared. When counsel's staff called to request the documents, the clerk advised that the court had to, quote-unquote, give permission before releasing public records. Even though it did not contain any confidential information and was not under seal. After weeks with no response, written requests followed. The clerk eventually claimed her office had no bond order. After several more emails and a specific request for an explanation, the clerk produced a bail bondsman's form. When defense counsel asked for a written statement acknowledging the absence of a court order for Fossler's bond, 2 weeks after the first request, the clerk finally produced a partial order, quote-unquote, ordering the bond. The bond order provided by the clerk, however, does not match the documents sent by the state several months prior. It is altered to contain a case number, although the case number does not return to any open case on case search and is not the number for Fossler's criminal case. That's crazy. The bond order that remains inaccessible to the public. Administration Order Number 2, requiring properly labeled docket books, including search warrants and affidavit warrants. I'm not sure what that is. Arrest warrants for warrant dockets. detailing what is properly filed in warrant dockets and requiring transfer of any such filings to the corresponding criminal case. The only constant in these irregularities is the assigned court and the control over the record. The pattern of withholding and gatekeeping of public records extends beyond a single instance. In December 2024 and January 2025, after 3 weeks of follow-ups by phone and email, the circuit clerk, acting under the court's supervision, produced only 2 documents in response to requests for the entire case file, then ignored follow-up inquiries. On multiple occasions, the clerk told defense counsel's staff and others that she needed the court's permission to provide documents, including in situations where no sealing order or cause for sealing existed. This was also the circumstance when counsel requested both sealed and unsealed certified documents. According to the clerk's comments to counsel's staff, the court also appears to determine which filings are visible on the public case search system. For example, the charging information in Fossler's case remains unavailable online despite no reference to any specific minor. The pattern continues even this week. Redacted email from member of public seeking amended information filed in Spencer's case. The pattern suggests concealment and control over what the public knows about proceedings handled in the courtroom. The cumulative result is a system in which access to public records depends on the judge's personal discretion, contrary to law, to transparency, and to the principle of open courts. This court has repeatedly exercised its administrative authority in ways that hinder defense preparation, distort parity between the parties, and reinforce the perception that the court is personally invested in the outcome of this case. The resulting pattern, arbitrary scheduling, asymmetric burdens, and punitive rulings suggests not neutral case management, but deliberate hindrance of the defense's ability to prepare. Without prior discussion or necessity, this court entered a scheduling order that imposed compressed and impractical deadlines. The discovery deadline was 30 days after entry of the order, with all motions due 2 days later on a Saturday, and responses due on a date certain 10 days later. On the following Monday, the court issued an informal email ordering all motions filed that day. Responses were then due 8 days later. At that point, the state was consistently providing voluminous discovery materials to the defense. These overlapping and unrealistic dates left the defense with inadequate time to review discovery, investigate, and raise constitutional and evidentiary issues. When the parties jointly requested a realistic extension and schedule, and advised of ongoing discovery disclosures that would inform counsel's motion practice, the court granted only partial relief, setting deadlines for motions the Monday before Thanksgiving, with responses due the Tuesday immediately after the holiday week. Particularly in light of the state's ongoing discovery disclosures at that time, the resulting schedule effectively eliminated usable preparation time and forced defense counsel to choose between compliance and completeness. And see, the public didn't know any of this was going on because she doesn't let the public attend any of this or access any of this online. Shortly before the motions deadline, this court entered yet another unusual directive. All motions and replies, most often in these cases filed in a single pleading, for example, motion with an accompanying brief, were to be accompanied by separate briefs, and motions filed in the prior month and a half were to be filed with an attached brief. At that point, only the defense had filed a detailed, substantive motion and reply, while the state had filed one motion containing 6 general sentences. As is typical in criminal cases due to the need to address potential constitutional violations and adequately preserve issues for appeal, the defense filed the bulk of motions involving substantive issues and legal analysis. This new requirement imposed a greater administrative burden on Spencer's counsel, forcing duplication of work and diverting limited resources from substantive preparation. The court's later rulings reinforced the inference of retaliation for Spencer's successful challenge to the gag order. I would say that that's correct. On the motion's deadline, the defense filed a narrowly tailored motion to file certain pleadings involving Spencer's minor daughter, the victim and Fossler's underlying offenses, under seal. The motion explained that those filings contained sensitive personal communications with third parties unrelated to the issues in the case and sought to file them under seal to protect the child's privacy and emotional well-being. The state filed no opposition. The court denied the motion outright, stating, quote, "The court will not at this time have any court documents filed under seal," end quote, and permitting only the use of the minor's initials. Now, this is bullshit because she sealed Fossler's death certificate. She sealed everything that has anything to do with Fossler's case. But she won't seal his minor daughter's personal third-party conversations that have nothing to do with this case. Make that make sense. In this case, however, the minor's identity is readily ascertainable from context, and the use of initials offers no protection. The refusal to seal even the most sensitive material, where no party objected and where sealing is routinely granted in comparable circumstances, cannot be explained as a neutral application of law. It reads instead as punitive, a message that any party who challenges this court's authority, as Spencer did when appealing the gag order, will face maximum procedural resistance. The court's refusal to appropriately consider the request under the circumstances had the obvious effect of hindering Spencer's ability to seek review of evidentiary issues and make a thorough record of doing so without effectively harming his own child. It certainly gives the appearance that the court is prejudiced against Spencer from his efforts at overturning the gag order. By imposing rigid, unrealistic deadlines, demanding duplicative filings, and refusing basic protective measures for a child victim, this court has created the appearance that the rulings are driven not by efficiency or law, but by animus toward the defense. Each of these acts, viewed together, exemplifies why this court, continuing to preside over this trial, undermines confidence in the impartiality of the judiciary. The December 2025 pretrial hearing demonstrated conduct inconsistent with judicial neutrality. Through the rulings and courtroom management, this court fostered hostility toward the defense, amplified public perception of Spencer as dangerous, and imposed conditions that could discourage public attendance and hindered effective defense advocacy. Before the hearing, the court sua sponte entered an order removing the Lonoke County Sheriff's Office from courtroom security and declaring the court would make, quote, alternative security arrangements, end quote. What followed was a show of force unprecedented for a pretrial proceeding, particularly with a defendant not in custody and without any prior demonstration of propensity to escape or engage in courtroom displays of violence. Officers from at least 5 law enforcement agencies saturated the courthouse inside and out. At least 4, sometimes 6 Arkansas State police officers remained stationed around the courtroom at all times, one positioned directly beside Spencer. Additional officers occupied the hallways, stairwells, elevators, and all entrances. Police vehicles ringed the building and established another perimeter some distance away. Drones patrolled overhead. The officers escorted Spencer to and from the courtroom. Public attendees were not permitted to bring electronic devices into the courthouse, and all bags were searched prior to entry. The parking lots around the courthouse were closed and empty, other than police units guarding them. From the outside of the courthouse appeared closed to the public. This excessive display discouraged the public from attending and conveyed the message that Spencer posed a unique threat, an image wholly unsupported by any incident or risk assessment. Just a second, I need a drink. I had absolutely no idea that all this shit was going on. None. And neither did anybody else, because she is making everything unavailable to the public. Once proceedings began, the court's demeanor toward defense counsel was openly dismissive. The court expressed initiation about quote unquote late stuff, even though defense counsel has not missed deadlines, and launched into a rebuke. No more trying to get around doing a reply brief by doing a second amended, third amended, because the law hasn't changed since then. I know what is going on, and that's fine. You figured out a way. But the law did not change from one time when Mr. Kaiser wrote it and then Miss Casanelli wrote it, or when the prosecution, when theirs wrote it, and the next one. There was no change in the law. There might have been a change in what you stated, but there was no change in the law. I guess that's something she said. Although the remark nominally referenced, quote-unquote, the prosecution, in person it was plainly directed at the defense, naming Spencer's attorney's counsel had filed no amended pleadings, leaving the purpose of this administration unclear. What is clear is the tone, contemptuous and accusatory, unsupported by the record, and calculated to diminish counsel in open court. Moments later, the court interrupted defense counsel's argument with, quote, "Let me stop you right there. I enjoy the theatrics as much as anyone else," end quote. Such commentary on, quote-unquote, theatrics suggested that defense advocacy was mere performance rather than legitimate argument, undermining counsel's credibility before all present. I mean, this bitch is something else. The court repeatedly interrupted counsel when discussing evidence of Fossler's abuse and its relevance to the case. The following exchange captures both the court's hostility and its refusal to permit the defense to present a full narrative. Mr. Casanelli, or Miss Casanelli, "Well, Your Honor, the state hasn't presented evidence yet. Expert testimony is admissible when it assists the jury in understanding the evidence, and the evidence is going to be, in large part, about Michael Fossler's having abused this minor." The court, "Wait a minute." Miss Casanelli, "Having been charged with it." The court, "Wait a minute. We are not having a trial on Michael Fossler in this case. Do you understand? Michael Fossler never had a trial, okay? So we're not going there." Miss Casanelli, "So," in the court, "and we're not going to go there today in this." Miss Casanelli. So the jury's not going to know that Michael Fossler abused this minor, was arrested, charged, released on bond, and then came back and picked her up during the night? The court. I expect some of that to be done, but I also expect that the jury is smart enough to figure out things without your expert telling them what to do or what to think about the situation. I think you're only trying to confuse them and bring in things that they do not need to hear any more of. Ms. Casanelli. Well, if the state's position is that the minor was not abused, was not groomed, was not manipulated, the judge. I don't know, wait a minute. Ms. Casanelli, that, and then the judge. I don't think what the state's position on all that, I know what you say. I have read it, reread it in your motions. But I am telling you today that my jurors will be smart enough with the evidence presented and not this expert witness that you intend to call. And that's the ruling of the court. If you want to file something, I've already told you to do it. But that's it on this one. What a fucking bitch. I'm telling you what. By cutting off this line of argument and refusing even to allow contextual discussion of Fossler's conduct, the court effectively shielded Fossler's actions, the precipitating events of this entire case, from a fact finder's understanding. The court's insistence that, quote, we are not having a trial on Michael Fossler, end quote, ignored that Spencer's defense necessarily turns on what Fossler did and why Spencer reacted as he did. Fossler's conduct is integral and critical to an assessment of Spencer's actions. This restriction reflects not judicial efficiency, but suggests an effort to protect Fossler and the court's prior handling of Fossler's case from scrutiny. I totally agree. The court again departed from neutrality when the prosecution belatedly produced substantial discovery and notice of an expert and his report. The defense notified the court that critical data had been produced on the Friday before the Monday filing deadline, and that an updated expert report arrived the afternoon before the hearing. The expert himself admitted he planned to gather additional data and again revise his opinions. Despite the defense's request for time to review this late evidence, if not exclude it, the court ordered the hearing to proceed and instructed counsel simply to, quote-unquote, listen. This refusal to grant even minimal accommodation rewarded the state's noncompliance and deprived the defense of a meaningful opportunity to prepare further evidence of bias in administration of the docket. To ensure effective examination of the state's cell tower expert, defense counsel requested a ruling on a pending motion for pro hoc vice admission of an attorney awaiting Arkansas licensure after leaving federal practice. The attorney was more familiar with the expert's highly technical subject matter and would have been more effective in cross-examination. The state did not object, once again. The court stated that it, quote-unquote, already ruled on that yesterday, but in fact it had only emailed that it would not decide the motion before the hearing. The court refused to rule, and the attorney did not participate in the hearing. There was no conceivable prejudice to the state and no logical reason for the court to refuse to grant pro hoc vice status to an experienced attorney prepared to conduct the cross-examination, particularly when the state had only recently disclosed the materials. The only effort was to prevent the defense from using its most qualified attorney in that specialized area at a critical juncture. The court still has not ruled on the motion. The continuing and unexplained delay has left the defense unable to allocate trial responsibilities or prepare fully, further undermining confidence in the court's impartial administration of this case. The pretrial hearing culminated in a public accusation of misconduct against a member of the defense team. The attorney was seated with other staff on the bench reserved for the defense team, directly behind counsel's table over the railing. While a lengthy video exhibit was playing, the attorney used her phone to research an evidentiary issue at lead counsel's request, when she was abruptly singled out and publicly sanctioned. The court stopped the video, pointed, and shouted, quote, "Ma'am, you're out. You go outside the courtroom right now, and you stay out the rest of the day. Now," end quote. When the lead defense counsel explained that the ejected individual was an attorney assisting the defense team, the court responded, "I don't care. There's no phones during this recording and stuff going on. She can exit the courtroom. If I see anybody else with a phone while this stuff is going on, they will exit the courtroom." There had been no prior instruction restricting phone use by counsel. The phone the attorney was using was in silent mode and in no way interfered with the proceeding. Roughly 30 minutes later, the court again abruptly stopped the video exhibit and escalated the incident further. "All cell phones are out of this courtroom. There's somebody texting what's happening in this courtroom, and they're talking about jurors and everything else. If it's not, I'll have each one of you search for a cell phone. Everybody leave your cell phone outside this courtroom now." The court elaborated, quote, "Somebody's texting what's happening in this courtroom. I don't know if it's that lady I got rid of a while ago or what. It's a text." So she's watching social media while there's hearings going on. Unbelievable. This exchange then followed. The court: "You can put it in your bag as long as it's not on. Turn it all off. I want to know if that lady was sending out stuff. If that was the one, Miss Casanelli. I'm sure it wasn't. I'm 100% certain it wasn't. She's a lawyer at my office, and she was probably texting us information about. She's doing legal research for us and texting us what she's finding." Well, the court says, "Miss Casanelli, she absolutely would not do that." The judge: "This has to do with 4 jurors and everything else. Only anybody that came in here after lunch knew about that." When defense counsel sought clarification, the court claimed that, quote unquote, someone had posted about the hearing on social media and implied that the dismissed attorney was responsible. The court was mistaken in asserting that only someone present after lunch would know about the voir dire procedures. They had also been discussed earlier that morning. No actual jurors were identified, only that 4 potential jurors would be questioned individually during voir dire. The hearing was public, and media representatives and the public did not need phones in the courtroom to lawfully report during breaks. Such reporting enjoys full First Amendment protection. Wow. No evidence linked the defense team to any posting. Nevertheless, the accused attorney, an officer of the court, was humiliated and barred from returning. The episode publicly branded the defense as untrustworthy and disobedient despite the absence of any rule violation. This ejection of a defense attorney during the December 18, 2025 pretrial hearing also functioned as a pretrial courtroom closure. The attorney was excluded from a public criminal proceeding for the remainder of the hearing without notice, without findings, and without identification of any interest that could justify exclusion. Partial closures, no less than full closures, implicate the Sixth Amendment right to a public trial and most satisfy the framework set out in Waller versus Georgia, as adopted by Arkansas courts. The court's own statements demonstrate that the exclusion was not biased on disruption, safety, or witness intimidation, but on a belief that someone was reporting on the proceedings via social media. That rationale cannot support a courtroom closure. Once a hearing is open to the public, truthful reporting of what occurs inside the courtroom is constitutionally protected. The fact that a member of the public or press relays information about a public proceeding, whether orally or through social media, provides no lawful basis to exclude anyone from the courtroom. Even where courts confront concerns far more serious than those asserted here, such as alleged threats or intimidation, a courtroom may not be closed without evidence in the record and specific findings justifying the restriction. No such evidence or findings were made. The court did not identify an overriding interest, did not consider alternatives, and did not tailor the exclusion in any way. The court's only concern justifying closure of the courtroom was a constitutionally protected activity. The summary removal of a defense attorney from the courtroom thereafter reflects the same disregard for constitutional limits on courtroom closure that the Arkansas Supreme Court has already criticized in this case, describing a quote-unquote troubling pattern of attempts to shield the case from the public view. The same pattern continued with the court's January 13th sua sponte order, quote, limiting courtroom occupancy and no recordings, end quote, which claims it is in service of, quote, the courtroom security, decorum, and the orderly administration of justice, end quote. In reality, however, it is a functional courtroom closure that mirrors and escalates the secrecy concerns that Arkansas Supreme Court already condemned when it vacated the gag order. The court will allow only 20 members of the public during voir dire, then cap total occupancy at 55 for the trial itself, including parties, counsel, staff, family, observers, and media, and limit media to one representative per outlet. With no overflow room, no video feed, and a hard head count that includes participants, the public is effectively locked out. This is a closure in everything but name. And she's not having it. The Arkansas Supreme Court has already warned the court about closing the courtroom without constitutional findings. Vacating the gag order, the Supreme Court cautioned that any closure requires, quote, an evidentiary basis and adherence to the required constitutional analysis, end quote. Quote, the sittings of every court shall be public, end quote. The concurrence described, quote unquote, a troubling pattern of attempts to shield this case from the public view. And from a closed arraignment to sealing the case, suggesting that the order on review before the Arkansas Supreme Court was not an isolated problem, but rather indicative of a quote unquote star chamber-like atmosphere. The Supreme Court emphasized that secrecy erodes public trust, and the concurring justices urged reassignment. Under Weller, any courtroom closure, partial or full, requires 1, a specific overriding interest likely to be prejudiced, 2, a closure no broader than necessary, 3, consideration of reasonable alternatives to closure, and 4, adequate findings to support the closure. None of these prerequisites are present in the court's courtroom closure order, in direct conflict with Waller and the Arkansas Supreme Court's express guidance. There has been no disruption, disturbance, or security incident, no identification of any overriding interest, no narrowing of scope, no alternatives considered, and no findings made. Like the vacated gag order, this restriction reflects a continuing disregard for the constitutional framework that guarantees public access to criminal proceedings and Spencer's right to a public trial. Separate from its effective closure of the courtroom, the court's January 13th order also imposes sweeping and unjustified technological restrictions that cripple the defense's ability to function at trial. In addition to capping attendance, the order bans, quote, all recording devices, including cameras, cell phones, Apple Watches, iPads, recorders, and eyeglasses, end quote. As written, this prohibition extends to laptops, tablets, and phones used by counsel, even when not used to record. The court had previously informed defense counsel that the courthouse lacks any private workspace for the defense or defense witnesses. The combined effect of these directives is to isolate defense counsel from their own staff and information sources during trial. There is no factual or legal justification for such a ban. The record reflects nothing that would warrant treating attorneys as security risks. Attorneys are officers of the court and subject to professional discipline. Counsel already possess the materials that will be presented at trial and can obtain certified transcripts afterward. rendering the prohibition unnecessary and irrational. The order's practical consequences are severe. It prevents defense counsel from performing core trial functions, coordinating with staff and witnesses, accessing digital exhibits and notes, communicating in real time with assistants, and researching evidentiary issues as they arise. Attempting to print and duplicate every potential reference document in advance is both impractical and impossible given the complexity of the case, the volume of discovery, much of it digital, and the length of accumulated pleadings comprising the record. The burden is also asymmetrical. The state maintains offices in the same building within steps of the courtroom and thus retains full access to electronic resources and personnel. The defense, by contrast, is stripped of its tools under threat of sanction. Such imbalance serves no legitimate purpose and only reinforces the appearance that the court distrusts and disadvantages the defense. By preemptively barring counsel from the technology necessary to perform their duties, the court has created a functional obstruction to the right to a fair trial. These technological restrictions, layered atop the effective closure of the courtroom, deepen the perception that the court's administration of this case departs from neutrality and transparency. She's just fucking going for the jugular. I love it. The court's gag order is management of public records, is conduct during the pretrial hearing, and its most recent restrictions all reflect a continuing effort to shield these proceedings from the public view. Those efforts are directly on the public's ability to evaluate the conduct of the public officials and make its own assessment of this proceeding against Spencer. Public concern has been widespread over the treatment of both Fossler and Spencer by local officials. The Arkansas Supreme Court's decision vacating the gag order reaffirmed that public discourse and scrutiny of official conduct are protected, not prohibited. Transparency is therefore essential both to ensure Spencer's right to a fair trial and to maintain public confidence in the judicial process. Just one second. My mouth is so dry, but I want to get through this. That's why I'm just fucking flying through this. I hope I'm not going too fast. If I am, just play it on slow. Following that decision, however, the court's conduct has exhibited the hallmarks of retaliation prohibited by the First Amendment. Spencer's successful petition for a writ of certiorari was protected activity under the right to seek redress of grievances. The court's subsequent actions, including publicly reprimanding defense counsel, restricting courtroom access, imposing unprecedented limits on electronics, even for attorneys, and closing the courtroom to those who are suspected of reporting on the proceedings, constitute adverse actions that would deter a reasonable person from further exercising these rights. The temporal sequence and pattern of punitive orders strongly suggests that these measures were not neutral case management decisions, but a response to Spencer's exercise of protected First Amendment rights. Retaliating against a litigant for invoking appellate review is incompatible with the impartial administration of justice. Despite the mandate for public trials from the Arkansas Supreme Court, the court has consistently acted to limit what the public may see or know, except when Spencer sought legitimate protection for his daughter, protection that courts routinely afford in far less sensitive circumstances. The court's selective secrecy sends the opposite message: that Spencer is too dangerous for a public trial, that the public cannot be trusted to witness it, and that those who speak about it may face sanction. The cumulative effect is to insulate the actions of both the state and the court from public scrutiny until well after the fact, when only fragmentary recollections remain. That secrecy fosters the appearance of bias and undermines respect for the judicial process itself. Moreover, because Spencer is a declared candidate for public office, the constitutional stakes are even higher. The public has a legitimate and heightened interest in transparent judicial proceedings involving political figures. Although this case will ultimately be decided by a jury, the role of the trial judge in shaping that process cannot be overstated. The presiding judge will rule on admissibility and scope of expert testimony, resolve motions in limine, address objections in real time, and determine whether witnesses, particularly law enforcement witnesses, are providing responsive and complete testimony. These rulings will directly affect how the jury understands the state's investigation, the handling of evidence, and the credibility of the state's witnesses, and ultimately the strength and merit of the prosecution's case. The court's demeanor and treatment of counsel also impact the jury's perception of counsel and its assessment of counsel's credibility. Imparting disdain or disregard unfairly jeopardizes counsel's ability to effectively advocate for the defendant. The court's responsibilities take on heightened significance here because substantial aspects of the defense will focus on investigative failures by local law enforcement, including the failure to secure and preserve critical evidence. The court will be required to rule on objections, evidentiary foundations, scope of cross-examination, and relevance when those failures are explored before the jury. The court will also be required to decide whether law enforcement witnesses may be impeached, whether omissions or investigative shortcuts may be characterized as such, and whether expert testimony may highlight gaps in the state's evidence and the credibility of law enforcement witnesses. Against that backdrop, the court's close professional relationships with local law enforcement create an appearance problem. Regardless of subjective intent, a reasonable member of the public would question whether a judge with long-standing institutional ties to the very agencies whose conduct will be scrutinized can impartially adjudicate objections, evidentiary disputes, and credibility determinations arising from those failures. Your Honor's continued involvement risks undermining public confidence in the fairness of the proceedings. That concern is further magnified by Spencer's current status as a candidate for public office. Spencer is now a political actor and, by extension, a political adversary of a public official who is expected to be a witness in this case and with whom the court has worked professionally for many years. Spencer has openly criticized that official, the court, and the prosecution regarding the handling of this case and other matters of public concern. Those criticisms constitute protected political speech, but they nevertheless place the court in a position where its rulings may reasonably be perceived as entangled with institutional loyalty and political context. Spencer's candidacy did not arise in a vacuum. He decided to run for public office in significant part because of his experiences with public officials in connection with this case and his perception that those officials failed to protect his child, failed to conduct a competent investigation, and then sought to hold him criminally responsible for the consequences of those failures. Spencer has campaigned on those experiences, criticizing the conduct of public officials, handling this case as emblematic of broader institutional problems warranting public accountability. In these circumstances, the risk of undermining public confidence in the fairness of the proceedings includes the risk that unconscious influences arising from long-standing professional relationships, public criticism, and political context could affect or appear to affect judicial decision-making. Even conscientious judges are subject to unconscious influences arising from long-standing professional relationships, public criticism, and the adversarial dynamics of electoral politics. Well, yeah, because these judges are elected officials too. Where a trial judge is repeatedly called upon to rule on objections, evidentiary disputes, and witness credibility involving a political adversary and a longtime professional associate under the unique circumstances presented here, a reasonable observer could question whether those rulings are or appear to be influenced by considerations outside the merits of the case. The concern is reinforced by the procedural history detailed above. The court has repeatedly acted in ways that limit public scrutiny and constrain the defense's ability to fully present its case, while the state has faced no comparable restrictions. When viewed alongside the court's role in earlier decisions that set the case in motion, these actions compound the appearance that the court is not positioned to preside as a neutral arbiter over disputes that directly implicate the conduct of law enforcement and public officials with whom she has close institutional ties. Under the governing standard, recusal is required where a judge's impartiality might reasonably be questioned. Here, where the court will be called upon to decide whether the jury hears the full extent of investigative failures by a law enforcement agency with which she has close professional relationships and where the defendant is simultaneously a political candidate and an outspoken critic of the institutions involved, reassignment is necessary to preserve both the reality and appearance of a fair trial. Conclusion. The responsibilities of the court must be carried out by a judge whose impartiality is beyond question. Any reasonable member of the public aware of the history of these proceedings and the claim of events that led to them would conclude that the court's impartiality might reasonably be questioned. For the reasons outlined herein, it is respectfully submitted that your honors should recuse from further participation in this matter to avoid the appearance of partiality, and that the case be reassigned to another judge for all future proceedings. Spencer additionally requests that the court seek the expedited appointment of a judge to hear this matter so that the trial may proceed without unnecessary delay. Spencer does not object to the court entering an order of recusal without a hearing. However, if the court declines to do so, Spencer requests that a hearing be held on this motion. Respectfully submitted. Now, like I said, my only concern is that he is going to be retaliated against should she not recuse herself. And he says, that, they're supposed to go to trial next week, 4 days from now. They're supposed to start jury selection. And if they do recuse her, then they have to bring another judge in, assign this to another judge, and then this judge has to bring himself current on all the happenings of the case so far. The judge has to read read the record and everything in it and look at all the evidence and look at all the, pretrial hearings and whatnot. That's a lot to cover and to bring yourself current on in a week. I don't think it can be done because we're going under a week now and they haven't even ruled on this yet. So that's if they, reassign a judge to this case before Friday. If not, and a judge gets reassigned on Monday, the same day they're supposed to start jury selection, how's he supposed to become familiar with the case, I'm afraid that might affect their ruling. That's a thing that I'm very concerned about. But I don't see how they can't honor his request, given everything that's in that motion. And yet we didn't know about half of it. And that's because she's keeping the public from knowing the details of this case because she knows she fucked up. Plain and simple. And she knows that her job as a judge is on the line at this point because, if all this shit gets out, It's election year, honey. And I don't think you're going to be reelected with all this bullshit becoming public. And rightfully so. So, anyway, that's all I have for today. I'm sorry it was such a long stream. I'm sorry I went through it so fast, but I just wanted to cover it before I had to lay down for work. And it doesn't look like I'm going to get to do that anyway. So, I appreciate anybody tuning in and watching this stream, and I hope you find it as exciting and as interesting as I do. And keep the Spencer family in your prayers and get the word out that this man is being wrongfully tried for a murder that a killing for a killing that only transpired because of what the court ultimately did. The court is the cause of this whole debacle. And the public needs to know that. So get the word out, show your support, donate if you can. This is not going to be cheap for him. And, his daughter needs counseling probably for the rest of her life after this. So, yeah, keep the Spencer family in your prayers, and I will keep you updated with any new findings. Hopefully, we'll get a ruling soon, and I'll be able to bring that to you. So, in the meantime, stay safe, stay warm, stay dry, stay happy. It's not hard. And again, like and subscribe. It's free, and I would appreciate it. All right? So, until next time, bye.